Hey everybody, tonight we're going to finish up with the Supreme Court cases. This is the last part of Unit 2B. So 2B goes really fast. A lot of it is actually Review 2, that being the Bill of Rights part. So be prepared for a test coming up really soon. So for the need to know, 2.11 it says to analyze the phrase, the Constitution is a living document. So we understood 200 years ago when we wrote this thing that it was, our times were going to change, that the Constitution needed to be able to move and bend kind of with the times. So the Supreme Court definitely helps us out with that. So tonight, overturned, search warrant, and Miranda rights are your key vocab words. So as you watch, I'm going to try, as I am doing this, to give you the amendments that go with each of the Supreme Court cases. It just makes it a little bit easier to be able to match everything up. So if I don't, make sure that you get those down for yourself. All right. So the very first Supreme Court case was in 1803. So the Supreme Court was brand new. It was laid out in the Constitution, but just not very well. So you already know this one. It is Marbury versus Madison Judicial Review. There's not an amendment that goes with this. It really wasn't about amending the Constitution or changing the Constitution. It was about what in the world the Supreme Court was actually going to be able to do. So it gave itself the power of judicial review, which determines whether or not laws or actions are constitutional. The next most important one for this particular class is Plessy versus Ferguson. I'm sure that most of you have at least heard of this at this point. This is in 1896. No, you do not need to know the dates off the top of your head. I don't know most of the dates off the top of my head, so don't worry about that. But basically what it said is that separate but equal is okay. Okay, now obviously this one has changed over time, and it changes shortly after this, but it took 60 years to figure out that this was not actually constitutional, and that it defied the 14th Amendment. You know, the 14th Amendment says everybody should be equal. So again, Plessy versus Ferguson, separate but equal is okay. 14th Amendment. You really can't talk about Plessy versus Ferguson without now talking about Brown versus Board of Education. Again, it took almost 60 years for people to figure out that maybe separate but equal is not actually equal. And so this overturned Plessy versus Ferguson, and it said, in fact, that separate but equal is not okay. Okay, again, dealing with the 14th Amendment. This is Miss Dollery Mapp. Okay, and she is one of the main people in Mapp versus Ohio. She is very outspoken during this time period. She's do some Google research if you want to know more about her. But basically, the police came in her house looking for a person, and instead they found something. They thought that she was harboring a criminal, and in fact, they found something else that was illegal, and they took it, and they arrested her, and they put her in jail, and tried to track her for this crime, and she was like, hey, you guys didn't have a search warrant for that particular thing. So this is why now search warrants have to be specific about what they're going in for. If they are searching the house, they can search the house but not the garage, or they can search, the house and all the attachments to the house and things like that. So again, search warrants have to be very specific in order to avoid people like Dollery Mapp getting away with crimes that were crimes when they were committed because the evidence was obtained illegally. All right, Engel versus Vitale. Okay, Engel and Angel kind of look and sound the same to me, so that's how I know that this is talking about religion. Okay, this is basically outlawed prayer in school. Now, there's a difference between having a silent prayer than having a school-led prayer. Like, you'll never see Mr. Switzer come on the announcements and say, everybody bow your heads and then lead a prayer, because that's against the law. All right, this is Mr. Gideon. Okay. Gideon versus Wainwright was in 1963, and this gentleman was accused of a crime that he did not commit, but he also was not the smartest person, and he was he was made to defend himself in open court without being obviously a lawyer, and he was sent into jail. And upon arriving in jail, he decided that, you know what, I can do better than this. So Gideon versus Wainwright, the right to a lawyer. Obviously, this is the 6th Amendment, and he also deals with the 14th Amendment, saying that he was not treated as an equal. This is my favorite picture ever. I'm not really a cat person, but it's kind of cute. All right, Miranda versus Arizona, 1966. This particular case, this gentleman had committed a crime and was basically caught red-handed. But what ended up happening is that he was not informed of his rights when he was being arrested. And so later on, he came out and he's like, well, I had no idea that I had the right to remain silent. I had no idea that I didn't have to talk to people and that I could have a lawyer and all of these things. So now when the police read you your Miranda rights, they read it because of this gentleman right here. All right, so we can talk about a couple of different things. If you listen to the Miranda rights, you have the right to remain silent, right? That's part of the 5th Amendment. You have the right to an attorney, again, part of the 6th Amendment. All right, Swan versus CMS. Now, this is probably not something that the state of North Carolina is going to test you on, but it's really important coming from kind of where we are right now in CMS and what CMS is hoping to do and planning to do and at this point trying to do. So Swan versus CMS was in 1969, and basically what was found by a judge is that busing to end segregation is okay. And so what ended up happening is that people were bused from all over the Charlotte-Mecklenburg school system to different schools in order to desegregate the schools, and that was okay. Up until about the 1990s, in 1991, there was a judge who came back and said, okay, the schools are desegregated, so you can go back to having like neighborhood schools like we think about today, the one closest to your house, and we have zones based off of all these different things. So CMS is revisiting this, so we will see how it plays out in our current day because it's a little bit further away from 1969. All right, these two kids right here, Tinker versus Des Moines, decided they wanted to protest. Again, if you look at the date, this is during the Vietnam War, and they were protesting the Vietnam War. So what they decided to do was to have these black armbands, and they were going to wear them to school. And of course, the school suspended them, and their parents fought against it in court and took it all the way to Supreme Court. And Supreme Court said, you know what, symbolic speech is protected by the First Amendment, and as long as you aren't being disruptive with your symbolic speech, then you have the right to be able to basically wear these black armbands as a sign of protest. Now, again, this does not mean that you can wear whatever you want to school and be like, well, Tinker versus Des Moines, da 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 da. This does not mean, your midriff with spaghetti straps is appropriate in school. There's going to be different rules and regulations for things like that. New Jersey versus TLO. Okay, New Jersey versus TLO deals with search and seizure in school. What we have is something called in loco parente, which basically means that while you're at school, we are in place of your parent. Okay, so if your parent wants to search through and go through your backpack or go through your purse, then that parent has the right to be able to do that. If we as teachers, administrators, school counselors, the SRO, have probable cause, then we have the right to be able to search and seize stuff from you. Now, that does not mean that you leave for lunch and your teachers are going through your backpacks. That's just not our role. It's not the relationship that we want to have with a student. But if there is something that probable cause, you're coming out of the bathroom smelling like something that you shouldn't be on school campus, then that gives, especially the SRO and administration, probable cause to be able to search you. And that's what happened here. All right, Texas versus Johnson. That takes a really long time to pop down there. Okay, 1989, again, as a sign of protest, a gentleman burned a flag and was arrested. And so when he fought against it, he said, I have the right to be able to have my freedom of speech. Okay, so burning a flag is protected by the First Amendment's freedom of speech. Now, just because you can do it doesn't necessarily mean that you should do it. So there is a difference there. But again, you have the right to be able to do this. So freedom of speech, First Amendment. Now, I also realize now that I'm coming to the end of this, and I might not have given you all the amendments for every single one of these things. You guys are super smart and can totally figure this out for yourself. So let me know tomorrow if you have any questions about who goes with what and which amendment goes with which Supreme Court case. But I think I got like at least half of them, so I'm feeling pretty good about myself. Have a good night, guys. All right, so Supreme Court cases, you thought I was done. I thought I was done too. I forgot that we have these two last ones. North Carolina Supreme Court cases are strange, to say the least. One of them makes sense. The other one, I'm going to let you kind of duke it out for yourself because it's really hard for me to even be. All right, guys, so State versus Mann. State versus Mann, I actually have the date up here wrong. It was 1829. So this is before the Civil War. But the Civil War really was a culmination of so many different things, and we'll talk about it more in U.S. history. But State versus Mann said that masters could not be prosecuted for assaulting their slave. Again, the slave was considered property in the 1800s and 1700s in this country, and so therefore in the North Carolina Constitution, and according to the North Carolina Supreme Court, State versus Mann says that, yes, you can beat your slave, you can assault your slave, and again, slaves are property. Leandra versus North Carolina was in 1997, and so what basically happened is that every student was constitutionally guaranteed the right to a sound basic education. Okay, so this is placing requirements on schools. You have to have highly qualified principals and teachers and things like that. So if you look a lot about what's going on in education right now, this idea kind of plays out more in like the charter school type of situation and in rich versus poor school districts, where there are different socioeconomic groups and socioeconomic systems in place that basically is everybody getting the same basic education. So again, if you're resorting back to like Swan versus CMS with a lot of this stuff, you can see where all of these things are headed and where they might use prior cases in order to be able to make their modern day case. The end. Oh, that was fantastic.